Right now we are overburdened. Magistrates generally have to take work home. You got to write your judgments at home. You got to do your research in your own time.
Long judgment.
You got to type your judgments yourselves. You cannot say that there's something special in the High Court. There is absolutely nothing that is special. That is why we've become radicalized, not just as JOASA, and in terms of all the lower court judiciary. We have taken to the streets, as you've seen.
No, you have.
We've stood before the union buildings picketing. We've been to Parliament. We've picketed outside Parliament. We've been to the Constitutional Court. At Constitutional Hill. We've picketed there in our gowns, mind you.
We are the custodians of human rights.
Yes, as a nation.
And the perception is when these politicians are there, they have such superficial questions. Is that because they don't understand?
We've got instances where our magistrates are being assaulted in court. One of our magistrates was hit with a bottle whilst in court. They get sworn at. And what's the point? We become toothless if we say, order in court, I'm holding you in contempt. But where's my court orderly? You need to take this person down to the grill or to the cells because we need to hold an inquiry because of their conduct. But we can't do it.
What do you end up doing?
We have to adjourn court because it's embarrassing. If you're an advocate or an attorney, you can earn what a magistrate earns in a month. You can earn that in a day.
Yeah.
So why would you want to become an acting magistrate or join the judiciary?
It's not an attractive
It's not
job.
attractive at all.
Yeah.
King David Studio Podcast.
We're faced with the challenges that South Africans, our court systems seem to be more complex than we realize. And something that comes up often, and we've seen it in the past few months, maybe even years, that judges are protesting. It's something that's unprecedented. We've never seen it in this country, but it's happening more and more. There must be a reason because protest is always the last line of any disagreement. So surely there's a problem. We managed to get a hold of two people in the studio who know this backwards. Dr. Betty, who has written on this with her thesis for her PhD, and also has been a judge for over 40 years. Understands this probably better than most of us. And also the Judicial Officers Association of South Africa's president, Neelan Karikan, who's here with us to give us perspective. How are you guys doing?
Quite well today. We are actually quite grateful to be here in studio to get the message out there. We've been throughout, and I'm sure we're going to get into much detail as we move on. But thank you so much for allowing us to be here.
I appreciate it. Thank you so much, Dr. Betty.
Thank you so much for hosting us here today. It is an opportunity that we just couldn't miss because of how serious the matter is.
Was it inspired by the previous conversation I had with Judges Matter?
Absolutely.
I think, yes. That's where the lady who said, Cherise, who said we should ask King David to do this for us because we do need it quite badly. So I'm grateful. Thank you.
You are based in KZN, Dr. Betty,
Yes.
Betty,
Yeah.
and you traveled all the way here for this chat. Surely it must matter.
Indeed, it does. In fact, I would have somehow made a plan to come, and I think it is just so incredibly important to have even a little bit of a platform, especially now that we're just a distressed institution.
Yeah.
We talk about us lower courts being the distressed institution, but in fact, if the lower courts are distressed, that means the whole judiciary is distressed.
Whoa.
And they don't even realize it.
You've spoken about judges taking to the streets. Remember, in terms of our positions, I'm currently a senior, that's what we regard ourselves as, a senior district court judge. Ms. Rawheath is a regional court judge.
Yeah.
We refer to ourselves as judges because the old colonial term magistrate has actually passed its sell-by date. And
Explain that.
you see, the retention of the term magistrate no longer fits in within our judicial system. Because what we actually do is exactly what the High Court does. We are applying the same law.
Yeah.
And you've mentioned that we might have been inspired to get in touch with you because of a previous, because of their engagement with you. And we've been through that interview. It was a powerful interview. It was an important interview. But to our mind, the concentration of issues relating to the High Court judiciary and High Court judges, that was sufficiently exhausted. Unfortunately, when it came to the lower court judges, and we do 95% of all judicial work in the country, and that you can say is a fact. And we are not effectively and properly recognized. There is this gap. In fact, we at one of our conferences regarded the situation as trying to bridge the judicial divide, because there is a division between the High Court.
Doesn't look like it from us.
Yes.
And because based on our ignorance.
And that is largely so because there's a deliberate, and I'll use the term deliberate and intentional attempt by various stakeholders to maintain the status quo, to keep the magistracy where they are. And that should never happen, because you will realize that in the regional courts already, they are implementing and they are able to sentence criminals that are convicted for premeditated murder, sexual offenses relating to children, to life imprisonment.
Yeah.
And remember, that's the maximum penal jurisdiction you can give in the country. You can be a judge. You can be a constitutional court judge that might confirm certain decisions.
Yeah.
But that's the maximum. But you can do it in the magistrate's court, but you still want to call that person a regional magistrate when he's supposed to be a regional court judge. And when it comes to quantum judgments, monetary judgments, civil judgments, our jurisdiction is technically unlimited, particularly when you are dealing with contracts where there's agreements to deal with matters in the magistrate's court. So we can give judgments for millions of rands. And we have the National Credit Act that also allows us that. So that discrepancy and division, we want that to change, because in essence, what we are fighting for is a single judiciary. And in the work that Betty has already concluded, and in a thesis, she makes it very clear. And we will share that if you didn't already receive it.
Yes, I did get it.
Yes, and it's very important. She clearly outlines how a single judiciary needs to be achieved, what legislative changes should happen. Remember, in our constitution, our South African constitution, magistrates are not reflected. There's just a reference in passing to the magistrates' court. And then we become created through an act of parliament, the Magistrates Court Act. How can that be? Sense.
It's old, that magistrate court.
It's old.
The Magistrates Courts Act was passed in 1944. That means just as the Second World War was ending.
And apartheid was in effect,
Well,
just about, yes.
You see, there's a little bit of a sinister background here. What had happened was, when the Magistrates Courts Act was passed, it was actually a development from an older law, which was from 1917. In fact, it's the same kind of judicial legal provisions that were passed under the Magistrates Courts Act of 1917, was then amended and slightly adjusted and became the Magistrates Courts Act of 1944.
Crazy.
36 of 1944. And then you must remember the Nationalist Party came into power in 1948.
That's it.
So what happened in they simply moved it from the English colonial system into another colonial system, which became the apartheid law. And when it became the apartheid law, it stuck. And then the law that was started as magistrates came from England. We all know that. But it enabled the apartheid government to keep the lower court still attached to the executive.
It was intentional.
Absolutely intentional.
Yeah.
We were just very much an arm of the executive government.
Absolutely, yeah.
And there was magistrates who did in fact apply the laws the way the government of the day wanted it interpreted and applied and enforced.
Yes.
So it was a serious discriminatory kind of process.
I want us to do this quickly, and this is my fault. I want us to give me a 1 minute, 2 minute background of your work and what you've done over the years, and why in the world would you do a PhD so late in your life?
Yeah.
Help us with that.
I regarded myself as just not feeling comfortable with any kind of discrimination or any kind of injustice.
Got you.
Even as a teenager. So I'd become conscious of developments in the area of politics. So I think it was political, but I didn't want somehow to be involved with politics. If I wanted to, I could have just done political science.
Of course.
But I wanted to do something where I can change how people are treated in terms of justice.
Put effect to the unfairness.
Yes, basically it was unfairness.
Yes.
And I was lucky enough to have had exposure to a lot of the newspapers. My dad was avid newspaper person who would have the newspaper there. So for me it was easy to actually follow everything that was happening in the world. I was curious about it as well.
Got you.
So, and then it was a no-brainer for me. The moment I finished school, I knew I wanted to do law, but I didn't want to be a litigating lawyer.
Okay, all right.
I didn't want to ever be in private practice.
You wanted to...
I wanted to actually do whatever it meant. I didn't know at that time where I needed to be to do what I really felt was necessary.
Got you.
So I started thinking, okay, it must be about law. So I got engaged. Well, my first law degree was a BA law degree.
Yeah.
And then I decided that as I'm finishing my BA law degree, I realized that I need to see where I'm going to go with this. And then it seemed a very big jump. I wasn't going to be able to actually get to doing justice if I followed the normal course, going through articles and going around all over all of that. That sounded a bit tedious to me.
Yeah.
So I found out from someone who knew about courts. It just happened to be someone who used to go past me when I was hitching a lift to university. He happened to be a prosecutor at Cater Manor Court.
Gotcha.
And he was the first ever magistrate from the black community.
What?
He just happened to be that. So I found out a lot from him every time I used to get a lift with him. And then he said, oh, okay, why don't you just apply? There's a new court opening in Chatsworth. I was living in Chatsworth. Why don't you just go and apply? Maybe you can get into there. And that's how I got that job virtually immediately.
As a clerk?
And I finished, as a clerk of the court.
Yeah.
And then I wanted to finish my LLB. And that's when
then it was the longer process.
Yeah, and then
the junior degree and then LLB.
Yeah, and then the LLB took me a long time, but they funded it. Because that time we used to get funding if you were once inside the department, as long as it was related to a law degree.
Yeah.
So I got the funding, got the LLB. After a year of being a clerk, I became a prosecutor.
There so through you were right there.
The same kind of journey Neelan had. So became a prosecutor, and then I prosecuted seriously.
You hung around as a prosecutor for a while.
For a while, yeah, and then and the natural thing was at that time they didn't want to mix up the demographic sort of thing.
It's during apartheid.
I really find it hard to talk about us in terms of Indian and African and white. I find it hard to do that.
We didn't design this. We found it this way.
Yeah, now that is why it was because of that I ended up having this position as as a magistrate in Chatsworth because
They needed
someone to serve Chatsworth
Got you.
who was a magistrate of Chatsworth. They weren't going to put me in Durban court because there's a lot of white people there. You know, I mean, how can an Indian do stuff?
Exactly. Yeah, no.
So that was the thinking. But I was grateful because we had developed a fantastic legal community, a judicial, what I call a court community.
You've been in the court for over 40 years.
Yes. Actually, clerk of the court for 1.5 years. And then the rest of the time in the courts, but as a judicial officer for 42 years.
Sure. You know the system
Yeah.
backwards. And you've worked for the department largely most of that time.
Nearly all the
of
time.
that time.
In fact, all of the time. We still do in a way.
No, absolutely.
And your journey quickly?
Yes. You see, our journey, Dr. Rawheath's journey and my journey, and when I speak about our journey, I'm speaking also about the masses within the magistracy. And within the magistracy, we've got colleagues that are, as you can see, more than 40 years in the system, 30 years in the system. So they're very senior people with the same legal qualifications as high court judges. Many of them come from being advocates, attorneys, prosecutors, academics, and they fall within the magistracy. And in terms of our trajectory, a lot of us came from administration, starting off as a clerk of the court, becoming a district court prosecutor, a regional court prosecutor, ultimately joining the bench in Gauteng. I emanate originally from KZN, District of Inanda, and then to Randburg, Alexandra, Civil Section, Johannesburg Central. I'm currently the senior magistrate in Randburg in charge of the civil and the family courts. We are one of the busiest courts in the country as it stands. So our position as the judges of the district and regional court, and we don't even like to use the word or term lower court judges because it's kind of give the impression of some type of inferiority.
Yes.
It cannot be.
Yeah.
So that's how I've gotten involved. And when it comes to judicial activism, that is something that's very new to me. And I've only joined the leadership of JOASA, the Judicial Officers Association, very recent. We've got colleagues in the organization that has been there for more than 10, 20 years. But what has happened is we are technically forced to become radicalized because everything that we've been doing is not achieving the results that we're supposed to achieve. Remember, you've spoken about us or judges taking to the streets. And how did we get there? It was not something that happened overnight.
Of course.
Remember, we've got different stakeholders and role players, from the president of the country to parliament, the different houses. We have the Minister of Justice. We have the Chief Justice. We have the IRC, the Independent Remuneration Commission. We have the Magistrates Commission. You've got the Judicial Service Committee.
Yes.
Look at all these different entities, and then nobody takes ownership of us in the lower courts. Nobody.
Explain how, to the layman, me, how this is designed. We know its history, but how is it designed? What is the hierarchy of the system? You were kind of doing it now.
Remember when Dr. Rawheath spoke and there was an indication of something being done deliberately. Everything that happened previously in terms of the apartheid system and when the Constitution kicked in, there was supposed to be some type of transition that was going to happen over time. If you look at Schedule 6 of our Constitution, the minister in the form of the Minister of Justice was supposed to fast-track and implement legislation that would implement a single judiciary. That never happened. Our government and our Constitution, as great as it is, neglected the greatest portion of the judiciary. That is why we say we don't have a single independent judiciary in the country. The fact that you have the high courts, that's fine, that's one component. But we are 95% of the system. High court judges comprise just over 200. We are close to 2,000, maybe a little less, but we are the majority. We are the cold face. When you need to go to court, you come to the magistrate's court.
If there's a stabbing, I'm likely to see you.
You must see me.
Yes.
You must see me. You will not go to the high court.
Of course.
And we are the court of first instance with the largest jurisdiction.
God.
So maintenance, domestic violence, harassment, civil matters, equality court. Remember, we also
You are there.
We deal with these things in the regional court, in the district court. We are dealing with all of them. Apostilles, urgent applications, evictions. So why are we neglected? I can only draw one conclusion. This is also deliberate. Why would Parliament not be passing legislation that implements and fast-tracks a single judiciary?
With what intention?
All right, let me just help you.
Yes, please.
I think what is very important is for us to focus on what the Constitution says, within the four corners of the Constitution.
100%.
So the courts are structured. The system is the highest court in the land is a constitutional court.
Yes.
Below that is a Supreme Court of Appeals. Then you get the high courts. Now that consists of the judiciary proper. They call it themselves the judiciary.
Okay. Independent of executive, independent of what's that? Of parliament.
Correct.
At least pseudo-independence.
Because they get money from them.
Yeah,
Yes.
mainly because it's pseudo at the moment because they don't have complete administrative independence.
Got you.
All right, because money comes from them.
100%.
So, and then now there's a chasm between those three levels and the lower courts. So
I
it's like,
thought you were part of them.
no, we're not.
Because it only makes sense for one to think that you are all the judiciary. Because you're all, if something happens, you are the courts.
We are the courts.
Yes, all of you.
But we need to say to each other, we need to understand, the important thing to understand is that the judiciary is located in the lower courts where the people are.
Okay.
If 95% of all dispute resolution takes place in the district and regional courts of the country, how can you say that the higher courts are in fact the judiciary? And we're not.
What do they call you then?
Nothing.
Technically, they've been using that term, the magistrate.
They're calling, there's no such thing as a magistracy.
It still exists in the
But
Constitution.
Not the
it's
term.
that word
Not the
is
term.
not the term, but it's like a convenient term to lump us down there so we can be seen as different and as the other. So it's othering in a way.
Also, the design is trying to, and you put it other. Other also creates hierarchy, creates power, creates layers, creates VIPs, and then the masses.
By the way, the word other is in fact in the Constitution.
Yes.
What? Where's that?
We are called
that was
the
that table
other.
somewhere.
We are actually called the
other.
others.
Remember, in principle, when you look at it from the outside and the same impression you have created, that when you look at the courts from the highest court to the lowest court in the magistracy, there is this impression that is the judiciary.
Yeah.
That is the system. But in reality, and it's more about the way in which the lower courts or the lower court judges or district court judges have been systemically discriminated against. Because you need to compare a high court judge from a district court judge.
Yes.
And why are things differently? Why are benefits different? Why do magistrates still belong to the government employees' pension fund? Judges don't belong there.
What is their setup?
Judges get salary for life.
Yeah, I know that.
They don't pay towards any pension fund. So what you see in terms of cost to company, what they earn in terms of what is gazetted, is what they receive. Magistrates have to contribute towards a pension fund from their salary. And when, and Ms. Rawheath, it's good that she is here. to highlight the fact that she's entering retirement now. She's not going to be getting salary for life. In fact, she's going to be taking a reduction in salary because you don't get your full salary. It's more in the region of about 70%. So right now, she needs to downgrade. And remember, she's been contributing for the last 40 plus years towards a pension fund when a High Court judge doesn't contribute. That is just one discrepancy. I'll just name another. And as we move along in this engagement, you'll see and it'll be glaringly evident as to the discrimination against the district court judges and regional court judges. Yeah. After 15 years of service, a High Court judge receives 2 years of salary as an ex gratia payment tax-free. So what does that tell you? If a High Court judge is earning, say, 1.9 million, 3.8 million after 15 years as an ex gratia payment you receive.
Yes.
On and above getting salary for life when you retire.
Whoa.
Magistrates or lower court judges or regional court judges, they get nothing. They get an absolute zero. After 20 years of service, a magistrate can sell 10 days of their own leave. Instead of going on leave and to pay debt,
they sell
their own leave.
And overwork themselves.
After 30 years, they can sell 20 days of their own leave. Now, what type of a benefit? Who is trying to hoodwink who here? We're all educated people. We're very senior in our game. And we are being treated like this by officials and stakeholders. Many of them do not even have the same qualification as the lower court judiciary. It cannot be.
There's a sinister part to this. It's not only about money.
I can only imagine.
It is so serious. What happens is that, especially since after democracy, we've got the JSC, which now is the body that is responsible for the appointment
of judges. We've all seen those interviews.
Yeah, and it's extremely politically slanted.
Well, naturally, because it has the people who represent the people, who are parliamentarians.
But the problem with that is it's good that there has to be a people represented. But if it becomes, in our country, we have a party system. A party decides who is going to be in that commission. All right.
Yeah.
So you got a commissioner coming from the cabinet, from the ministry, who is now going to be in charge of appointing judges.
Not only from the minister, but also from parliament.
Exactly, yes. But I call it the political wing.
Got you.
As opposed to the judicial wing.
Can I push back for a second?
Yeah, sure.
And say it is the political wing by design because politics represents the ordinary people. Am I correct in making that interpretation?
That is
so technically, it's me as an ordinary South African who's being represented in that room. You seem to have a problem with that. Help us get your perspective.
Look, it would have been in order if that political kind of thinking doesn't offend against the concepts that we have to work with the judicial independence context.
Got you.
But I've found that in nearly every interview for judges, that it's nearly always slanted in such a way, or either ignorance or a lack of understanding of what judicial independence is. The kind of questions that they ask these contenders for the judges, the candidates,
yes,
is so is lacking in any insight.
Okay, of how the system.
I mean,
works.
how the system works,
yeah.
And if I'm going to represent you, let's say I'm a member of parliament, I'm in the commission, I represent you. Mustn't I be sure that the judge I sent to the bench actually understands what my needs are of justice?
That is the innocent expectation of you representing me. I'm expecting you to understand my problems, so you represent me perfectly.
Now, the question you would ask is how can you ensure that a right that is is enshrined in the Constitution has that application every time someone comes to your court. Let's say an example. Someone has been arrested, awaiting trial, has to be released on bail.
Okay.
What I would ask as a representative of Parliament, so on what basis would you grant someone bail if he's charged with, say, a murder?
Yes.
That's the kind of question I'd ask.
It's a simple
because
question.
it's a simple
question in law, right?
Exactly. It's
Okay.
very simple for that person to answer it. But the way he or she answers it is what's going to make you think, okay, this is made of a solid human rights background
Okay.
and has a potential to be able to actually ensure that people who are appearing before her are going to be ensuring that there is justice.
Gotcha.
The human rights are always going to be the center of everything I do. We are the custodians of human rights.
Yes, as a
But
nation.
and the perception is when these politicians are there, they have such superficial questions. Is that because they don't understand?
Look, if you put me as a commissioner who comes from Parliament, and I'm a commissioner in the JSC, my knowledge of the law is very limited. Even if you gave me a 2-hour crash course, it still will remain. So I don't think I'm in the right position to interview you to be a judge.
You made my point.
Sorry to interject.
Yes.
I'm not really going to get into the way in which judges are appointed and
Appointed,
magistrates. That's quite a complex issue. But it's very important for us to not lose focus and make sure that we understand the state, the current constitutional crisis we are at. And in the lower courts, remember, we have already engaged all the stakeholders I've mentioned, from from the presidency right down to the Magistrates Commission. We've engaged them and everybody agrees. We've been in Parliament more than twice already.
When you say they agree,
They agree that the magistrates lot, and lower court judges in particular, they need to change. There needs to be systemic legislative changes. And the fact that everybody agrees, it's almost as if we agree and then that's it. Who needs to act now? It has to be the minister. The minister needs to institute legislative changes through Parliament to fast track, because the Constitution calls for that type of intervention to fast track a single judiciary. There's only now this talk after 31 years of democracy.
What sparked the talk?
What sparked the talk? And we'll be honest about it.
Yes.
Because the lower court judges or regional court judges, district court judges, they have become radicalized because nobody looks after them.
Strike now.
Let's start with the fact that we have no recourse.
Yes.
That's the main reason. If you are a unionist, if you belong in a trade union, you can down your tools. I'm not going to.
As a collective.
But we have no right to do that. We can't go anywhere.
So your action, your protest action is quite bold.
It's
It's
exactly
very bold.
that. That is why you call it unprecedented.
It's bold, it's radical. Now you will see even the judges themselves. Remember, we have been calling to the judges. I mean, they are our seniors. We look up to them. I mean, our decisions go on review, go on appeal to the high courts. Just as high court judges' decisions can still go on appeal within themselves.
Of course.
So we're no different. And we've been appealing to the high court judges. A lot of them come from our ranks.
Of course.
And
They
they've
got
become
promoted,
judges.
right?
They've become judges.
Yeah.
They've become judge presidents, deputy judge presidents. They're going all the way to the top. So they're no different from us. They know what it is to have been a magistrate in the country. So we expected them, and that is why we are pushing them and forcing their hand, that they need to pick us up also. They know what we are doing. We're doing the same work. So why are you letting us fall behind systemically? And remember, prosecutors in the country, currently, a lot of them earn more than magistrates. And they are supposed to be our juniors. We are mentoring them. We are ensuring that whatever happens in court, remember the pinnacle in any court is the judicial officer.
Of course,
And that's
yes.
what we are. How can we have more junior people below us, earning much more
That's
than
what
us.
I was trying to say to you when
Yes,
we are
when
on
we were
our-
traveling here,
It's
yes.
exactly that. The buck stops with us, and to put it in a colloquial way.
Yeah.
Because everything that happens in the court is about what the court decides. So
And that's you.
That's us.
Yeah.
And every ruling, a decision whether a case should be postponed or not, a decision whether a warrant of arrest should be granted or not, a decision whether a case must be postponed for 2 days or whether it should be postponed for
For
6
a year,
months
or a year.
or several months.
Yeah.
Or let's get this case completely off my roll because it shouldn't be here. The decision stops with me. So it's a lot of decision making, which is what we are supposed to be paid for.
Yeah.
That is not taken into account when it's being decided. Oh, you go there and you sit and you make rules. It's not that simple because everyone who appears in your court is a special person to be dealt with by someone who understands you, understands your circumstances, and understands the circumstances of all the others who are here because you want your case to be dealt with
100%.
fairly.
Really what you're describing is the size and scale of the responsibility that you hold.
Absolutely.
And yet it's not understood. Or if it is,
Yeah.
let me ask dumb questions and allow me this. Why is it that it's not understood by the senior judges who came through the similar ranks as you? Shouldn't they be helping with this fight?
I've got a difficulty with the approach taken by a lot of colleagues that have passed through our ranks and entered the high court realm. And it seems that when they enter the high court realm, there is some type of induction that possibly happens.
That makes them forget.
It's almost as if they metamorphosize into another entity.
Into a butterfly.
But they use the same law in the High Court. If they've done murder cases in the regional court and you do a murder case in the High Court, it's exactly the same principle, same law, Criminal Procedure Act. The law, the specific
same.
crime is exactly the same. The way you analyze the evidence and give your judgment when it comes to sentencing, all the principles as applicable is exactly the same. And you give a full judgment just as the judges in the district and regional court. It's exactly the same.
But
There's this elevation of, let's say,
Importance. You
that
can use that word.
importance,
You can use that.
importance, remuneration, protection, security. Remember, we're talking about medical aid, we're talking about security, we're talking about tools of trade, which we don't have. We're talking about basic stuff, infrastructure. As a judge of the regional court, we don't have researchers, we don't have judges' clerks. Every judge, when they're appointed, you get a researcher, you get a judge's clerk.
But magistrates?
Magistrates get nothing. We don't have PAs.
No.
We have the administrative staff that's supposed to give us support staff, and even they are lacking. The Department of Justice does not have sufficient manpower and clerks. In Randburg Court alone, one stenographer who runs the machine and records has to run more than one court. How can that be?
One guy.
One person
Yeah.
got to run from one court to the other. There's insufficient clerks. The filing system is a problem. And there's a lack of magistrates. There's not enough courts. Right now we are overburdened. Magistrates generally have to take work home. You got to write your judgments at home. You got to do your research in your own time.
Long judgment.
You got to type your judgments yourselves. You proofread it yourself. We don't have the luxury of researchers to assist us as compared to anyone in the higher courts. So we do all of that, and then we still have to be taken on review and appeal. We are answerable, not the prosecutor, not the attorneys. We are the ones that are answerable.
To your
And we
own
are held,
judgment, yeah.
and we are held, mind you, to the same standard as a high court judge that has all these benefits that a lower court or district court judge does not have. And when you compare the judgment and ruling here, and we are the most overworked.
Of course.
When you talk about domestic violence and having about 20 to 30
Let me
matches.
tell you how I've
bad.
navigated it in the
Yeah,
regional
how
court.
have you done it?
We do what is I do.
I feel like I'm wasting your time here. You should be writing a judgment.
Yeah, you know, you actually are free today because I do what is called extempores.
Okay, what is that?
Extempore means
Latin.
I hear all the evidence, hear the closing arguments, and give my judgment immediately. Extempore.
Okay. Got you. Yeah.
And that comes
Yet,
with experience.
Yes.
It's only with experience that you can do this.
Yeah.
Because I have to listen so carefully. So that's why I always mention that my hearing needs to be very good.
Very sharp. Yes.
So that is why every word, sometimes it's not comfortable. Remember what I said about how stressed people are.
Yeah.
They come into the courtroom. Some of them will speak really fast, because they're nervous. And there are others who drop their voice a lot.
Because they're nervous.
They're nervous.
Exactly.
So I have to understand that. I can't tell you, speak up.
No.
That would be wrong.
You have to be empathetic
So
to their
I'll have to tell them, look, I'm struggling to hear you, but I understand that you speak that way. But so please bear with me if I'm going to ask you to repeat yourself.
Yeah.
So all that means that I have to take care of those people who are going to say things in court because they impact other people's lives besides their own.
Yeah.
So I don't want to take months and months. These people are waiting for me.
Yeah, that's another thing. All you described leads to delays.
And then Dr. Rawheath does not have the luxury of time. Remember, generally in the higher courts, they have running rolls. Oh, if you have a murder trial, it's set down for like a week. And they generally have watertight cases that end up in the high court. You know, the ones that are not that strong, they keep down in the lower courts. You know, because they'd rather get convictions up there.
Okay, then.
So if you look at our courts, our rolls are so congested. You can have 2 to 3 trials set down. Then there's parterres, there's postponements, as compared to dealing with one matter over a week.
Beginning to end.
And finalizing. You've seen on TV all these cases in the High Court. They just carry on running. And you wonder...
Forever and ever and ever.
If there's so much of matters on the roll, how is it that this judge is dealing with this case for one...
Yes.
Has the luxury...
Senzo case.
I'm going to be very crude. And has the luxury. And if you look at the cost implication of having that judge to deal with matters, when in the regional court, they are finalizing matters almost daily and creating parterres. So it's unimaginable. That is why Dr. Rawheath, when she says she's forced to do extempore judgments, but it comes with experience, but at the same time, she needs to clear her role because we are accountable.
Yeah.
People are watching us. We need to finalize a case from beginning to end within a stipulated time based on the norms and standards of the Chief Justice. So we are held to account. And that is why we are under pressure. And, you know, our quality could even be better, you know.
Imagine, as I was saying to you earlier, imagine someone, someone had killed a child, and now the parent has to wait for that criminal case. It's a murder, right?
It's going through investigations and so forth.
Yeah. So just imagine the mind, the thinking, and the feeling of this mother who's lost a child into an unlawful killing. Now, imagine if there's a day in court that we have set up for that case. Come that day, our recording machine is not working.
Oh, no. That same guy that's supposed to fix others in other courtrooms.
Yes.
Yes.
Imagine you telling that mother, you're not going to get closure on this. No matter what the outcome is, she wants to know what the outcome is, right?
On that day, you're likely to postpone.
It's postponed.
Yeah.
And imagine that kind of your life being postponed over and over and over again. And that's when people say, what are these courts doing? Why does it take so long? So we need serious understanding of especially the lower courts.
Let me interject for a second and allow me, because I want us to get to a particular point. You asked, why does it take so long? What is your answer to that question? If somebody was to ask you, my child was murdered 7 years ago. We still haven't had a finality. I've been to your court 7 times. You've postponed 6 out of 7.
All right.
What could be, and I know circumstances are not the same, but what could be the overarching reason for that delay?
The thing is that there's no overarching reason because each reason is a reason on its own merits.
Naturally, yes.
So every case, every time we have a case, just say one accused, you're going to have at least 8 people having to be there, besides the number of witnesses for the state.
8 people at the same time.
At the same place, at the same time, for any number of days that case is going on.
To constitute, if I could just come in there.
I wanted to conclude it, but I hope you're helping.
Yes, no, I will. To place in context, when we talk about the various stakeholders that are involved, remember you've got the prosecutor, you've got legal aid, you've got the interpreter, you've got the stenographer, then you've got the witness themselves.
Of course.
And then you need everything to function. If you are using closed-circuit television because the witness is in another room and it's a child, if it's not functioning, you can't proceed. If the machine doesn't work, you can't proceed. You don't have interpreter, you can't proceed. Now, as
you need
court,
an interpreter on that number of people?
Yes, and as court, you need to constitute court. And you are responsible for the running of the court. And if one role player is not there, the whole system breaks. And then you end up
need 2
postponing.
police officers.
Oh, security.
in
Security.
the room. Yes.
And that's another issue.
Huge problem.
The aspect of security, very important. It's good that it was raised. Did you know? And as you say, you want to be informed, and you need to be treated almost you don't know anything about the system. Did you know that in our family courts we don't have court orderlies? In Randburg Court, and I'll name Randburg, is around the corner from your studio. And it's one of the busiest courts, mind you.
Every time I've driven there, it's packed.
It's very busy.
Yes.
When it comes to domestic violence, harassment, maintenance, children's court matters that affect the family and our daily lives, the excuse is there's insufficient SAPS staff to man our courts. And we've been crying about it at the stakeholder meetings, all the way to, we have all these meetings with the JPs that ultimately is chaired by our Chief Justice. Everybody's aware because it's minuted. Now, if the police are not giving us staff, and you say that we care about gender-based violence and the like, and these people are already fighting with each other, and they sit in our court.
They can't go back home together and assume nothing will happen.
And the magistrate sits on the bench and needs to deal with this case, and they still want to fight in court. And if you don't have a court orderly, you can't maintain order. And what are you supposed to do? We've got instances where our magistrates are being assaulted in court. One of our magistrates was hit with a bottle whilst in court. They get sworn at. And what's the point? We become toothless if we say, order in court, I'm holding you in contempt. But where's my court orderly? You need to take this person down to the grill or to the cells because we need to hold an inquiry because of their conduct. But we can't do it.
What do you end up doing?
We have to adjourn court because it's embarrassing.
And adjourning court
We have to
has
adjourn
an impact
We
on,
have to stay, we have
on
to
the
stand down out of
Get
fear.
back to your question. One of the reasons for the delay is because we have no security in the courts. If I will not start my court, especially if you have a person who's in custody. The other day, I don't mean to say anything negative about this person, but he's a police officer. Probably got up at 3 o'clock in the morning, right? So he's sitting there guarding someone who's awaiting trial, brings him in, puts him there. Now the court is busy, working trial. And as I'm the only one sitting on the bench, could see that the police officer has fallen off to sleep.
Of course.
Can you believe it? He's got a firearm.
And sitting next to
and now I can see the eyes of this guy going to... he's sitting there in front of me. So I attracted his attention. I said, whatever his name is, Mr. So-and-so, can you just focus your attention to what's happening
You're
here,
trying to
please?
distract him away from the sleeping policeman.
And that's when I had to call the court clerk. She's just below me, and just inform that police officer there that he needs to be awake or needs to stand up or do something to make sure that we're not on. Because the moment, imagine what chaos can happen in a court if that police officer is jumped on.
Yes.
All of us are in trouble, including himself, of course.
Of course. Especially himself.
Especially himself.
Yes.
And this... a good gentleman. I really appreciate him. But then that day I had to tell him, you need to be careful. And I told everyone there that this is dangerous. Please do not allow this officer who's so exhausted to have to do maybe double shift or what shift is. I had to feel for him because he can't himself go and say,
I'm tired. And maybe they also want the extra buck, I want to go back to the basics, to the basic questions.
Yes.
And these were quick fire questions with easy answers.
Yes.
What type of case goes to a higher court and what type of case goes to a lower court? And I'm using the word lower and higher because of that's the language that's used. Help me understand that as a layman.
Ordinarily, to my mind, and Betty will supplement, to my mind, the high courts currently are primarily being focused on reviews and appeals.
Okay.
Obviously, serious offences, murder, rape, and robberies, the serious ones can also end up there. They've got jurisdiction. But the bulk of the work that the High Court used to do has filtered down to the regional court and to the district court.
What has happened there?
Because of legislative changes. You must understand, in terms of our constitution and in terms of all the rights, the right to shelter, right to housing, and all the equality clause, all those different clauses have been well ventilated in the legislature. They've been creating beautiful laws. And everyone that needs to implement those laws filters to the lower courts. We implement, whether it's PI, prevention of illegal evictions and all of that, residential evictions, business evictions, ESTA, when you're dealing with farm evictions, all that we do. Equality court, remember, now that we also do. PAJA, holding power to account. We do it in the district court. So we're getting all this lovely legislation that's taking the work away from the High Court and filtered it down to our courts in our space. So we've got the volume and the bulk, but nothing else flows. When it comes to the benefits aspect and the protection and the security, we don't get it. We get everything. We do the work and we must not complain. And when we do complain, we are threatened with misconduct.
To answer your question about what's the difference, at this time, more and more recently, there's the one court level above the regional court is the High Court. The High Court does nearly all of its work, reviews and appeals.
Okay. What gets reviewed from your level? Am I correct?
Yes.
From your judgment, then there's
our convictions, our sentences.
Then somebody says
our procedure, our conduct can go on review.
It goes above.
It can go there for them to look at it. They'll either confirm or they can uphold the appeal.
Exactly.
That means our decisions can change. So it does not mean, I want to make this clear, because quite often our deputy minister and the past deputy minister particularly used to draw this distinction that the High Court has inherent jurisdiction and they create precedent. But you must remember, we write our judgments, it goes on appeal and it's largely confirmed. So when it's confirmed, who is creating this precedent? It came from the bottom. And remember in the High Courts, a judge that gives a judgment can go on appeal to the appeal court, which is another judge.
There's still another level.
So which means their judgments are also reviewed and appealed. So there's no distinction. You cannot say that there's something special in the High Court. There is absolutely nothing that is special. That is why we've become radicalized, not just as JOASA, and in terms of all the lower court judiciary. We have taken to the streets, as you've seen.
No, you have.
We've stood before the union buildings picketing. We've been to Parliament. We've picketed outside Parliament. We've been to the Constitutional Court. At Constitutional, we've picketed there in our gowns, mind you.
I've seen the videos.
And should we be embarrassed? We are fighting for justice. We're fighting for recognition. We're fighting to avoid and avert this constitutional crisis that we are at. Right now, the picketing hasn't helped. Remember, our cost of living adjustment we were entitled to as of the 1st of April this year. We have not got it. Just now on the 18th, the day before
18th of December.
18th of December. The IRC now publishes that there is going to be some cost of living adjustment. But they know fully well they were supposed to have implemented as of the 1st of April to have went through those systems. By the way, it's
still only a recommendation.
It still has to go to the president.
It's still a suggestion.
It's still got to go to the president who has a discretion. Then it must go to Parliament. And they know very well that Parliament is in recess. So when are we supposed to get?
Next year.
So we're not
And the
getting
major review, you've heard of the major review? We've been promised that 17 years ago.
Yeah,
And that's in
when
the
when I
pipeline.
read that, I couldn't believe it.
Can you imagine, in order to bridge that gap and change all these anomalies where junior people are earning more than magistrates, that was supposed to have been implemented and fast-tracked. The common issue and complaint is there's no money. Now, what are you saying? For an arm of government, you don't have money to look after the lower court judges so that they can pay their bills, so that they don't need to go under debt review. And you want to hold them to that standard. And yet you cannot give them proper care.
Incentives, yes.
And we're not asking for gold.
No.
We're just asking to be able to pay our bond, pay for our car, pay for our medical aid, pay
and
for...
our children's university fees.
But we can't. We can't make ends meet.
Let me connect the previous conversation I had with Judges Matters.
Yes.
Your case.
Yes.
Does Judges Matters look after your situations as well?
Judges Matters, they do good work.
Okay.
Let's be clear on that. But they could be doing great work.
Okay.
Because when we refer to Judges Matters, there is some entity that was created subsequently called Magistrates Matters. Now,
So again,
why? I did not understand why there was a need to have done that, because they already had the concept of Judges Matters. And when you speak of judges, you cannot only be speaking about the High Court. I know you might have an interest in the High Court and they are making more serious decisions and the judges sit in commissions and the like. But what about us? We've just described in a nutshell what is happening in the lower courts and the magnitude of the work we do.
Yeah.
Why are we not being recognized? Where are all the political commentators and the commentators who speak about the Constitution? Why have they not analyzed and researched to the extent that Dr. Rawheath has? Because you're literally neglecting this arm. What are you saying? Are you saying that the magistrates must be left to their own devices? And what is going to happen to the access to justice? And when magistrates do strange
Let's get to
things?
the point of access to courts. That's what Section 34 says. And if you noticed it, I've put it in that
Yes,
little
I
note.
saw that, yes.
Section 34 is the heart of my thesis. It's about access to justice is dealt with in detail in my thesis.
Yeah.
But the point that we are making is about, it's not only about our own service conditions. It's not only about our remuneration. Of course, the reason why we are here today was because we are fed up of being underpaid and overworked, right? But at the heart of my activism actually started, can you see when I started that thesis?
Yes.
I started researching for it in 2013.
Yeah.
That means I was already really unhappy. Let's say as I was researching it, I started to get more and more angry. I hate to use the word angry
So
because
it's
it's
an
not...
angry thesis.
Yeah, it's just incensed. Every time I looked at some study that divided us for no justifiable reason, I had to make a note of that.
Yeah.
And all those notes I started in 2013, putting together how badly discriminated we are. Then in 2016 was when I decided that I'm going to put this down in a doctorate. And that's when I registered with UCT. But the fact of the matter is, this terrible predicament that we are in has been developing
For years.
we thought when the Constitution came into place, we were fine. That's when we let our guard down. If it was still the old regime, we would have still been fighting. We can't have this. We can't have a magistrate's court. We would have been fighting. But we all fell back and said, okay, let's wait. Maybe something is going to... Nothing happened. So I started with this thesis. So to get to Section 34, it's the critical importance of Section 34 is that we are the spirit and the soul of what our people are dealing with in terms of their social interaction.
That's it.
Now imagine someone who comes to your court with any case, whether it's civil, criminal, he's coming to the court and saying, please help me with this. And then I say, okay, let's help you with that. And if I do not do my absolute best, and that litigant gets upset, that means they want to now take this to a higher level.
Yes.
And now that is where the problem is.
That's called an appeal, right?
That's called an appeal. And remember that if I am working as a shop assistant, I have a serious problem with something, I can't afford it. I can't take it to the higher level because...
You can't afford, because the higher level requires more expensive representation.
So that means because that person can't get access to a court, that person is being denied the right of access to a court.
Which when means being denied what they constitutionally...
What the Constitution is
supposed to be getting.
So the fact of the matter is, it is extremely expensive. I've also put it in the note there. The reason why we are so important in the lower courts is because we have to do a large number of work, volumes of work, speedily, effectively, correctly. Why? Because this person might never be able to get it to another level, even if you made a big mistake with your case. They will have to accept it because they don't have access to another court, because they can't afford it. The lawyers themselves in those courts are charged. Talking about lawyers, I mean, the lawyers, the counsels who appear in those courts earn more in a month than we do in a year.
As the very judges.
Absolutely. I want to just add, from everything that we've discussed, and remember, as an organization and as JOASA, as I pointed out, we've become radicalized, not by choice. And this conduct, as you can see, is clearly deliberate. If you look at the facts and you look at the amount of time that the executive tries to explain themselves, and if magistrates need to go embark on some industrial action, there is this complaint or aspects of misconduct where they might utilize acting magistrates to replace us in the event that we engage in some type of activity to protect our rights. And when I say this conduct is deliberate by these different role players, and these are very important role players, they are respected role players, and they are constitutionally created in our constitution to do certain things. Now, if it is deliberate, and we are looking at 31 years into democracy, now, if it's deliberate, what are we saying? Those role players, from the head of state to parliament, to the Chief Justice, to the Magistrates Commission, to the Independent Remuneration Commission, to the Minister of Justice, if that conduct is systemically, when you analyze it, it's deliberate, that is tantamount to defeating the ends of justice. You're going against the Constitution, because why else would you do this? What is the benefit? What is the end game?
I'm trying to understand that myself.
There is a money aspect to this, because magistrates are not getting what they are entitled to, the protection that they are entitled to. And for us to be left to our own devices, what are you saying? Are you saying you want to compromise the lower court judiciary? Are you want them to be affected by criminals who want to entice them? Is that what we are saying? Where is security of tenure?
Because that becomes complicated, much more complicated.
That is why, as when you discussed with judges' matters, those are the aspects that I would have preferred to also have been ventilated, because we are the coalface. And if we are not there, the system crumbles. There's nothing.
I'm struggling with this concept of this ball keeps being pushed forward.
Absolutely.
No one is attending to it.
Yes.
And yet, it seems everyone understands the importance of the role you play. It's as you say it, if something happens to me, if my car is stolen, we find the guy that stole it, it comes to you first.
Absolutely.
Before it goes anywhere else. Everybody knows that.
Correct.
I imagine even the Pala matter starts there.
Yes.
Am I correct?
Correct.
Well, it should.
It should. Because it's a criminal activity.
For a bail application at least.
100%. It starts with you.
Yes.
But then if everybody and all of us understands, and yet we live in a criminal-infested country, we have problems.
Yes.
We do.
Surely your situation should be urgent. Am I correct?
Absolutely. That is why I say deliberate.
But then I'm trying to
If it's
understand.
deliberate, then they need to account. They can be charged criminally, to my mind.
I think you should charge them.
You think so?
I think you should.
Okay.
I asked him last night.
Charge the president.
Thank you for
I
that
asked
advice.
Mr. Karikan last night to just stop me if I go off. And now I have to stop him.
I want to attend to something, to the remuneration issue.
Yes.
17 years of no reviewing salaries.
Yes.
Are we saying reviewing, or they've just been increasing in relation to inflation? What is the story? If you were earning 10,000, are you still earning 10,000?
You must understand something when it comes to the review. A review is a lot of talk.
Okay.
We've had a report. They've spent millions of rands previously to create a report. It had gone to the president. It became stale. Then it goes back. New company gets appointed to do a review. So that's reviewing.
Yeah,
but
the
nothing
review
gets
itself,
actioned.
You need to explain what the review is supposed to do.
Okay.
What's the review supposed to do?
Mm-hmm.
It was supposed to make sure that the work we do, in terms of our sense, our responsibility to society, to generally how we make our decisions, it's a responsibility that we're supposed to be looked at. Mm-hmm. But now we have not been. There's supposed to be a benchmarking process that takes place. Now, because they had not done that from 2007, that means we don't know. We absolutely don't know
what is the benchmark.
What exactly is supposed to be where we should be. Maybe I should actually be earning double the amount.
True.
So all we are asking for that review is to go into you have to compare with similar kinds of things that they do in the market. Mm-hmm. That's how you do benchmarking, right?
Absolutely.
I'm not very...
No. You look at it in relation.
But that's what is supposed to be done so that we can get the right, appropriate kind of remuneration for the kind of responsibility we have. Mm. Like the CEO of a company. I'm the CEO of my
your court. I'm 100%. And then you're not a junior manager.
And a lot of people's lives are in my hands.
Yeah. Wow.
And imagine being a CEO. I just read the other day, CEO of a retail store.
How many millions in bonuses?
Yeah. So that's a kind of thing that needs to have been done.
Yeah.
So we've been begging for this report. So why are they not doing it? It's exactly why I'm saying the sinister part of it.
You're harboring on the sinister part.
Yes.
Because you can apply it in most of areas in our country. You can apply it in education. Why is there no improvement? You can apply it in healthcare. Why is there no extreme level of improvement?
The difference is we are speaking about an arm of government in the form of the judiciary. Now that concept, if you cannot fathom that concept and you allow that institution to be discriminated to the extent that it has, and we want to go out there in the world and preach that South Africa has a magnificent constitution, but the judiciary is in shambles.
That's supposed to uphold.
And we've always created this perception that the judiciary has been holding the country together. Well and good. So largely they've been doing so, good judgments, holding power to account. But,
perhaps.
But if the majority of the judiciary...
Most of the time.
If the majority of the judiciary is treated the way they are or discriminated, remember I used the term systemic economic discrimination against a class of individuals in the form of the lower court or district court and regional court judges.
Yeah.
Now that in itself is a complete cause of action for the Equality Court.
It's a class action.
And it's going to have to materialize now because the powers that be have not achieved or actioned what they're supposed to do. Yeah. So beyond taking to the streets now, remember as lower court judges or regional court judges and district court judges, we are going to have to escalate. And what does escalation mean?
How high can you go now?
We are going to escalate in terms of what we are doing in terms of work to rule. You've heard of that concept.
What is it? Explain
work to rule is we will do what we're supposed to do. We start work when we're supposed to start. We take our tea break when we're supposed to. We take our lunch break when we're supposed to. Go back into court. Finish court when we're supposed to finish court. And when court time is up, then our job is over. all these judgments we are writing at home,
We'll never.
all these default judgments we are doing at home, all the research we are doing at home. So every ounce of work we do beyond what we are treated or paid for, that we've been doing for the last 20, 30 years, and there's no acknowledgement. When we do that, who is going to give you your judgments on time? Look at the court rolls. Why must we embark on that? But now you are forcing our hand once again. And the public at large
Public suffers.
obviously need to
That's
know.
the problem.
Public at large need to know. Because that is why we are embarked on that awareness campaign. I mean, if we're picketing and if the public doesn't care, then when we down our tools, what's going to happen after escalating work to rule?
Let's just talk about how good. You remember I just passed that little remark.
Yeah.
Perhaps it's because the highest court in the land has made some of the biggest mistakes that are now hurting us. That's what I call Fundroyan.
Correct.
You will see I mentioned in that little briefing
Yes.
the Fundroyan
I
judgment.
saw that. It's
A unanimous,
There's a quote there.
yes, the unanimous judgment of the highest court in the land as being the sole reason that keeps us divided between the higher and the lower courts and has completely destroyed every respect that our society should have for us.
Remind us of the fund, Roy. Give us perspective.
All right. The perspective is this. The Magistrates Act and the Magistrates Courts Act. So the Magistrates Act came into place in 1993 when the interim constitution was being discussed. So the Magistrates Act was supposed to be some kind of a transition
Okay.
before the Constitution.
Before the 96.
Yeah,
Yeah.
in fact, even before the 93 Constitution.
Yes. Okay.
And
It's when the apartheid was wrapping up.
They
so
were
to speak.
trying, yes.
Yes.
You must remember there were a lot of interests
Of course.
to make sure that the old system is not completely destroyed. So they wanted to, there was obviously what you call this, a little interest group that wanted to preserve some of what was there before.
The old
especially
order.
the old order.
Yes.
That's why I call it the old order law, because Magistrates Act is an old order law. But we were supposed to have used that to transition us into, instead of being attached to the executive as we were when we were magistrates, this moves us out of the executive insofar as our independence is concerned to a magistrates commission.
Got you.
So the Magistrates Commission now is in charge. Now, a case came up because the Magistrates Commission was decidedly not independent. That's what a group of people, the Fundroyan was the main litigant in that case, but so was ARMSA, which is the Association of Regional Magistrates. They decided that this commission is a serious attack on how lower judicial officers are functioning. And we cannot be, that Magistrates Act has got to be scrapped because it's not independent.
Was that the conclusion of the commission?
Actually, it wasn't the commission. It's this group, Fundroyan,
Okay.
and the ARMSA group decided to take this to court as a Fundroyan case against, at that time it was against the commission.
Okay.
So they took it to the High Court, and the High Court said, you're perfectly right. This commission is compromised. It is not independent.
It's important we pause. Why would they say that about its independence?
It's because there was an element of the Magistrates Act has several sections. It goes into hundreds of sections. But the one that was really problematic was the fact that the commission was not in itself independent of the executive.
Got you.
We remained as an appendage attached still to the executive, not any different from what it was during the apartheid years.
Help us with this distinction. Attached to the executive, which is cabinet, which is the Department of Justice,
Yes.
which is the president.
Yes.
How is the other arms of the judiciary, the higher court in that regard? How is it in terms of its independence from the judiciary? Don't they get money and funding from the same place? How different are you from other levels of the court system?
We are the executive.
Yes.
We're not the judiciary.
That's what I'm trying to
Yeah.
understand. You're saying
Yeah.
the finding is clear.
Yeah.
Even the higher court agrees with you
Yeah.
that you are attached to the executive.
Yes.
But is it the same with the higher court?
It's not. Absolutely
the higher
not.
courts, if I could just come in there, the higher courts, remember, the anchor is our Chief Justice.
Mm-hmm.
That is the judicial head. And that's very clear for the high courts. And beyond being that, they don't fall under any administrative control from the Department of Justice.
That's what I wanted to understand.
They have the entity called the Office of the Chief Justice. So they have their own budget.
I think it's on the highway.
Remember, they are able to argue for their budget in terms of independently, as compared to us in the district and regional courts. We are still falling within the auspices of the Department of Justice. Anything we need, pens, paper, and the like, is still falling within them. And we need to ask administrators for that support. And the level and degree of support we're getting is not up to standard, as you can see. So what do? We don't go to the Chief Justice.
No.
Ultimately, we're going into this direction.
Are you not supposed to go to the chief?
We ought to go to the Chief Justice.
But then why don't you?
There is this perception that we have a single judiciary purely because the judge president in every province exercises oversight over the magistrates court. But that's where it ends. Having a meeting here or there doesn't make us a single judiciary. In reality and in practice, everything is disjointed. So we want to streamline and make sure that there is one single budget. Some people think that if the Department of Justice is no longer needing to service us and we are independent, we have our own staff, all that needs to happen is the administrative component of the Department of Justice needs to just report to ultimately the Chief Justice, the judge presidents in the different provinces. We have chief magistrates, regional court presidents. They need to understand that they are accountable to the judiciary because you're forming part of the judiciary.
That's it.
You're not forming part of the Department of Justice. They have their own function. They've got a lot of other work to do. Why do they need to hold on to the judiciary? What's in it for everybody? Must be some.
That's the sinister question.
That's a cynical question. Once again,
I'm trying to also understand,
Yeah.
ma'am. Surely there's a compromise of an overreach of power in some way if the executive has its hand inside the judiciary. And by hand, I mean administrative hand, financial hand.
Yes.
And that should be obvious to everyone.
Yes.
Isn't it?
absolutely.
In fact, it's a minimum. It's a minimum standard of judicial independence that we must have financial independence.
Independence. But then how are you funded then? That would be my next question.
Well, it's supposed to be all our salaries are paid from the treasury. In fact,
Okay.
all government workers and judiciary gets paid from the national treasury. It's the way it's allocated. There is an administrative it's called the Office of the Chief Justice, who gets a budget for the higher courts.
Not for you.
But no.
Not for us.
No.
It's the Department of
Now,
Justice.
that's why I say we are still
So your
attached.
salary, it comes from the Department of Justice. It doesn't come from...
The Department of Justice is administratively in control of everything relating to money or administration, tools of trade, the running of our courts, the stuff that goes into it.
Lower
but
courts.
we,
Lower courts.
yes,
Lower
but
courts.
us as the judges of the district and regional court, we don't have control over them. We cannot give an instruction to a clerk, or we cannot just pick up the phone and call a service provider to attend. We have court managers that follow their own line function that ultimately ends up with the Director General and ultimately with the Minister of Justice. So where does the judiciary fit in these courts that we say we are running? The judiciary is not running any court. We're just going in there as a role player. We must take what we get.
The lift doesn't work.
Whatever the case is,
Yes.
you go and live with your own devices. We're giving you the power. You can give life imprisonment. You can give 10 years. You can give 3 years in the district court. You can give quantum judgments, put yourself at risk, jump into your car that's falling apart and drive down the street unprotected. You know, so we are to our own devices. And just on that, before I lose that point, when it comes to security, you might have already seen this. There's been different TikTok videos going out that directly has threatened a particular magistrate.
Yes, I've seen
and he's got an eyesight problem, and he's been insulted, calling himself, calling him like the justice is blind. But he's been threatened to be shot with a firearm.
Sure.
Between the eyes. That's the description. And more than one video went out. And action was not taken immediately. And that's going to be my point. Eventually he was arrested. But the police had to get involved. Then I'm told that the Hawks needed to get involved. Sure. So by the time the man was arrested, he was fearing for his life. He was almost in hiding.
Yeah, the judge was
You understand? And he's a district court judge.
And visually impaired as well.
And so where's the security for magistrates? Our magistrates' offices are getting broken into. In KZN, one of our PC members had his office broken into, laptops and the works damaged. So it's not unusual for a magistrate to be shot, to be attacked. So, and we don't have protection and security in the building. The security that is there for the purpose of protecting the building. Access control.
Not
to protect the judiciary.
Yeah.
We don't have allocated and dedicated judicial protectors. We don't have that.
I want to go back to a point that the narrative, the story that you were narrating about, the matter now is with the High Court. And the High Court judge says, yes, your independence is problematic.
Yes.
What happened after that?
So that matter, you see the way our law is, when it comes to a constitutional issue, which was about...
that is a constitutional issue.
It was a constitutional issue.
Yeah.
So whatever the lower court decides, whatever the High Court actually decided in this case, the High Court decided that the Magistrates Act has to be repealed in various sections. Had to be repealed. And he said some strong things about the lack of independence of the Commission. By the way, the biggest aspect of the Magistrates Act is about the creation of the Commission.
Okay.
The Magistrates Act created the Magistrates Commission.
Got you.
So now there was this challenge because they're not independent. And then it has to be confirmed. That is where the trouble started. It wasn't the High Court's decision that had to stand. Because it's a constitutional issue, it had to go to the Constitutional Court to be confirmed, like all constitutional issues. Instead of simply confirming, upholding what the High Court judge said, which was absolutely correct in my view, they decided that they are going to cancel it and they're going to invalidate everything that the High Court said about the independence of the Commission.
Essentially rendering
they
zero.
pretty much threw it out.
Yes, wow.
Completely and utterly threw it out.
Simple question, when was that? And what has happened since?
This was in 2001.
What has happened since? Picketing amongst many other things.
That's why I say that judgment was the best opportunity for the Constitutional Court to join us, because the Commission was not independent. That was the time for them to say, let this go back to Parliament.
Yeah.
It needed to be fixed, and that was the time which they had to unify.
Yes.
From that time, the lower courts were treated as if we didn't belong in the judiciary.
Well, it puzzles me, and it goes back to the points we made earlier. These are the same judges who came through the similar ranks as you.
Exactly.
Then why is it that when they get up there, they change their perspective?
Remember, this is our highest court in the country, the Constitutional Court.
You failed
and
there.
They largely give brilliant judgments. Even this judgment was well written. It was well written.
150 pages.
Well, it's a lengthy judgment, but it was just certain points that really destroyed any progress or transformation that needed to happen. And Betty is 100% correct that the Van Rooyen judgment currently entrenches historical inequality and discrimination. Why was it necessary to treat the judges of the regional court and district court differently? Why did they allow it? And remember, they are judges themselves. They are to the same standard. So now when we go to court, when we litigate, and we will be going to the Constitutional Court again, and when we go there, it's our own brothers and sisters who we are saying, you are our leaders, just align us and allow it to happen. Give time frames to the legislature.
It's the highest court, the apex court. You can't reverse anything they said. So we've got to try now. This
realign, refocus.
We've got to start from a different angle altogether. And the Van Rooyen judgment ought never to have been decided in that way. And so for me, if you ask me why they would have done it that way, I can put it down to hubris.
Yeah.
They were all so caught up in this euphoria of getting this constitution in place so that we can have this amazing democracy, which it was.
But with a lot of loopholes.
But there was such a lack of insight, such a lack of understanding the deepest levels of what this actually means for our democracy. Actually, they were undoing the democracy instead of building it.
Yeah, you are burning.
You can see that this Van Rooyen judgment, and we always come back to the aspect of deliberate. And there are just certain ways in which you can write a judgment, because we are experts in judgment writing in any event. And we know that we can write a judgment in this direction or that direction and justify it.
Yes.
And there's just a few things in that judgment that with the stroke of a pen that was just thrown in there, it had to have been deliberate, because when someone analyzes these judgments, they go in a certain direction and they kept the status quo
the same.
It had to have been deliberate. But remember, these decisions can actually change because depending on whatever issue that might end up in the Constitutional Court, and they might be constituted differently, and depending on the moment in the day and how we are evolving.
And who's leading.
And the argument can be accepted just as we get minority and majority judgments. The Constitutional Court as it stands can rectify the situation, and we're going there. We're going to be going to the Constitutional Court and asking for direct access to deal with these issues, because these are constitutional issues.
Yep.
They're not issues that we can just willy-nilly deal with, because it's going to end up there. So we'll go there directly on all these aspects that call for a single judiciary, and it's going to happen.
Mention one point about why that judgment went that way.
Yes, because I'm curious to know
why.
If you were to
Deliberate.
have a...
Remember we had...
You said deliberate, but maybe there's a
mistake.
Well, actually, whatever it was, but the end result was the same. But what I was thinking is that there was no precedent. They couldn't have actually got any case law, any authority from anywhere in South Africa. Remember, this is a South African situation. So where did they look?
Was the international lens?
They looked at the Supreme Court of the Canadian Supreme Court of Appeals judgment called Valente, which we'll also see mentioned somewhere in. They actually got their authority from two lines, pretty much, of the Supreme Court of Canada judgment, which says that a tribunal can be arranged in a way that does not all have to be in its composition as any other tribunal. Remember, they're talking about tribunals. This is not a court judgment. It was a court's judgment, but the decision was based on how tribunals make their decisions as to whether the tribunal is independent or not. So
And that's not the same interpretation as a court.
Exactly. We were already an independent court.
Yes.
Imagine applying rules of independence, judicial independence, that you apply to a tribunal and just carry it over and export it to make it an authority for a court which is part of the judicial system under the constitution of a country.
Let me understand this for all of us. So we circle back,
Yes.
probably to the beginning.
Yes.
Is our judiciary, if you were to ask a student in a law class first year to write a paragraph or maybe 2 sentences, is our judiciary independent from the executive as we speak today? And I note, I'm asking a bigger question,
yes.
not a small question of some parts of it. Is our judiciary independent from the executive today as we speak?
To my mind, it is not.
It's not.
Not at all. Remember, magistrates, and you'll see that there's a large component of acting magistrates that are within the system. There are close to 30 to 40%, to my mind, that are acting magistrates amongst us. For some reason that the Magistrates Commission doesn't effectively do their work, maybe because they're not capacitated.
Okay.
If there's about 7 or 8 positions available in a court like Randburg, they advertise 1 position and they have 7 acting magistrates. Why would that be?
Why should they act?
Do you
why
know
should
why
they can't be appointed?
It's dangerous. It's actually dangerous to the
finish the
democracy.
thought, yes?
You know why it's dangerous? Imagine if 60% of acting judges are now acting in these courts. And do you know what the issue there is?
Tell me.
The central issue about independence is what? Security of tenure. If you don't have security of tenure, you have no independence.
No.
Nothing at all.
Yeah.
But imagine an acting judge can be sitting there for 2 months and you got him contracted for 2 months and then you don't like how he's ruling. Out you go. Out. Go.
And we go again.
So-
Can you reverse that judgment?
Absolutely.
Start the trial again?
And remember, there is a judgment, there is a Van Wyk judgment that came out more than 10 years ago,
Yes.
dealing with acting magistrates. And I want to highlight that our acting magistrates, that's 30 to 40% of all the magistrates, they don't get their full salary. They don't get a pension contribution. They don't contribute.
While they're
they
acting.
don't get leave.
Yeah.
So there is a lesser salary paid to acting magistrates. All right, that's firstly. So there's a saving. And the Department of
Saving
Justice,
by the executive.
Department of Justice is getting our money to pay, and these are funded positions. Those posts are supposed to be filled. So if you don't fill it to that extent, then there's a substantial saving, which doesn't come to the magistrates. It ends up in the Department of Justice. So someone's benefiting there.
Yeah.
So in terms of budget.
Saving.
But there is this Van Wyk judgment. And I've been in touch with the attorney himself. He's an attorney, Mr. Van Wyk. And in terms of that judgment, it went on appeal. The declarator portion was overturned. But however, when it came to the fact that he needed to be paid the same salary as a permanent magistrate, that was implemented. It was implemented and he was paid.
Only one.
Him, individual, he was paid. But what about all the other acting magistrates? And even currently, the Department of Justice is not honoring that judgment, and that is precedent, mind you.
It is.
A precedent has been set.
That's why I ask, is that only
So
one?
our magistrates are currently not getting their full salary. And if you get sick, you don't get paid. Your salaries, you don't get vacation leave. Now, can you imagine these contracts that our acting magistrates are signing? Don't you think that's contra bonus mores? It's against good policy.
Of course.
Where's the Labor Relations Act? Remember, we're not protected. We don't fall within the Labor Relations Act.
Why-
We can't go to the CCMA.
Why aren't judges protected? Is it because there's a different system that protects them? Lower court judges,
It's always been envisaged that what the Constitution has created would work. It was envisaged that things will work. It was envisaged that the IRC will do their job. They will do their research. They will make sure that everything that needs to happen would happen. It was expected that the Minister of Justice, and we had many ministers,
Of course.
many ministers and deputy ministers, they all, unfortunately, they sing the same song. And They have not implemented legislative changes to bring about this single judiciary and implement the protections that we're supposed to have. So we, from the ground now, we got to fight for what we are entitled to. And who's going to pay us back? Nothing. No back pay.
The question why there are not more cases, get back to.
Yes.
That goes back again to the very issue of being intimidated.
Okay.
Imagine you are now going to take up an issue because you're not getting paid properly. You're not going to do it because you're not going to get your next contract. So it's pretty much saying to you, you are muzzled.
Yes.
That's what it is.
Of course.
That's why they're not.
You're strong-armed. Yes.
Yeah, absolutely. Because what that is abuse, I'm sorry to say.
Absolutely.
It is abuse.
It's total abuse.
Yeah.
And our point is that ultimately we want to make sure that you understand and the public at large understands. What do we want? We want the Magistrates Commission to do their job, to fill these posts. They are funded posts. Yeah. We cannot have acting magistrates that are there for 2, 3, 4, sometimes 5 years, and then you don't appoint them, and then you get other people who just come into the system and you appoint them.
They're disposable.
That's appointable. That's discrimination.
Yeah.
That's total abuse. So we want the Magistrates Commission to immediately advertise and fill in those posts. The excuse that we don't have the capacity, we are sitting as chief magistrates or we are commissioners elsewhere and we don't have the time to get it done, you have to make the time. If not, don't take the post.
Yes.
Give it to people who can do the job.
In fact, I want the Magistrates Commission completely disbanded.
Well, if I understand this entire argument,
yes,
the Magistrate Commission is not necessary.
It's
absolutely not necessary. And it comes back to that single judiciary.
Yes.
Remember, you have the Judicial Service Commission, and they deal with appointments of the High Court judges, discipline and whatnot. Then you get the Magistrates Commission dealing with judges that are fit and proper also, that went through the system and got appointed. Why do we have two entities when there should be one streamlined? Obviously, you'll save money. And look at the rules. Why do you have the uniform rules of the High Court and then you get the Magistrates Court rules dealing with similar issues, whether it's ex parte applications, summary judgments, exceptions, irregular steps, all of those things in the motion court, in civil courts, we do. So what do you call it? Why do you call that rule differently from this? And then there's no different in interpretation.
Not at all.
Yeah.
So we need the rules aligned. We need the JSC, the Judicial Service Commission, and the Magistrates Commission to be amalgamated. In fact, the Magistrates Commission should be dissolved. Because they only deal with misconduct.
Let me ask this question. Again, ignorance. The JSC appoints
High Court judges.
And who appoints you?
Magistrates, the Magistrates Commission through a process.
Yeah.
The appointment is still done by the minister.
That's what I wanted to get to it in the end.
Correct.
Yeah.
So, but the JSC, the minister is not directly involved. Because remember, it's a parliamentary process, so to speak.
No, they are not. It's not finally.
So that's the independence.
The president makes
the final
appointment is done by the president, signs it off.
Yes.
But the JSC makes the recommendation.
The recommendation
with
has
names.
to come from
And
to Parliament.
Yes, but to the president, it's his discretion. Ordinarily, the president does not deviate.
Yep.
Ordinarily, he would not deviate.
Not compelled.
Not compelled, but doesn't deviate. In the same fashion, magistrates, there's a recommendation from the commission that goes to the minister, and the minister generally abides, but not compelled to adhere. Because he can change, he or she can change.
Like NDPP's thing is going, and is it NDPP that's going on now?
Yes.
The minister is involved.
Ultimately.
Yeah.
Yes.
Ultimately.
But remember
that's another independence issue. But anyway.
Yes. That is another
that's a can
issue.
of worms, big story there.
Yeah.
But what's important about the Magistrates Commission is that they tend to, there have been several cases against them that were disputed. The appointments were disputed, several of them, because of the perception that some people might have got that this was not regular.
The appointment was not regular.
You know, there are people shortlisted there. Some of the candidates will be asked 2 questions, and the others will be given a day to answer the questions that are.
Wow.
So they're already earmarked somebody.
Oh, no. Oh, no.
Yeah, that's exactly what happens.
I want to ask another quick question. Unless you
in a nutshell, what's important is the process must be transparent. We cannot have individuals having the sway in the appointments committee, because then there's a conflict of interest. Because you have a relationship with the people that are being interviewed, because they either were in your cluster, subcluster, they were a magistrate acting in your space, so you have your own prejudice. So when it comes to that type of decision, obviously they ought to recuse themselves. The independent, they can guide the questioning, but they cannot influence and interfere ultimately with the way the interview goes on, because the best candidate ultimately must succeed.
Let me go back to another question that was asked before, because now I realize that the rules apply differently to higher court, and I'm getting enlightened.
Sure.
Bear with me, I'm slow. When your JSC is representing me, there are members in there who are commissioners during the JSC process of appointing a judge that represent me. Is my someone that I voted for during the elections. I crossed, and they got enough numbers to end up in parliament. And now that party, which is my party, has appointed this person to go sit in the JSC to appoint a judge for the High Court.
Yep.
But when it comes to the lower court, I am not represented. Am I correct?
No, you're not.
I'm not.
There are representation from political parties within the Magistrates Commission.
Yes.
The Magistrates Commission, when it comes to appointments and interviews, they have colleagues from the academia.
Okay.
They have advocates. You have a whole politicians.
Yes.
So there's a whole
similar.
It's quite similar in composition.
Okay.
But it seems that obviously the composition of the JSC is much more high-powered.
It looks like.
You know what? You have to be very careful there.
Yeah.
There's a lot of nuances there between the Magistrates Commission,
and
because in my thesis I've dealt with it extensively.
Yeah.
Because I wanted the Magistrates Commission done away with, and I had to now justify it, and then I had to go to what was called the first certification judgment, which dealt with the independence of the JSC people. And I had to draw the parallels there. And even during drawing those parallels, there's a vast difference in how that body is constituted in terms of independence.
The JSC.
Then, the JSC is a whole lot in a better position to appoint more appropriately qualified people than the Magistrates Commission, because the Magistrates Commission is overwhelmingly a political commission. Oh, sorry.
No, don't worry about me.
That is overwhelmingly.
That's problematic.
It's one of the reasons why the Van Rooyen judgment was decided. But the Van Rooyen judgment, I've dealt with it extensively in my thesis. One day I will try to break it down for you so that it can fit in with what I'm trying to say to you about why that judgment is problematic. It's not only problematic in those little spaces that I've told you. There's a whole plethora of justifications by the Chief Justice, by the way. He wrote that judgment. Cheskilson.
Yes.
Now late.
That's
he's a good guy, I know. But here he made a mistake.
And it's a repairable mistake.
That too we have to talk about. But because of, I know this is a lot of stuff that has to be somehow ventilated. This might not be the right platform. But it has to be understood that there's a huge difference between the JSC, how it's constituted,
and the Magistrates Commission.
The Magistrates Commission is just not suitable.
The Van Rooyen judgment uses the word sufficiently independent. That's the reference that it uses. Sufficiently independent. I know in law, words like that matter.
Yes.
I have a problem with the term sufficiently independent.
Yeah.
why should we settle for sufficiently independent?
Should be totally.
Need to be properly, effectively, totally independent. So that thinking and rationale was already misplaced. Just as, when we refer to our constitution of our country, when we come to the part that we are living and striving for freedom, we've achieved freedom, because I know a lot of colleagues in my space argue that why are we still struggling for freedom? Because that's what we are singing about it, but we've achieved freedom.
Yeah.
We have a democracy, we have a constitution, we are here, we have arrived. So let it happen.
Yeah.
We should not be, because right now, what's happening now, we are living our constitution because we are striving for freedom.
Yes.
We are struggling for freedom. And the powers that be should be implementing.
Yeah.
And the powers that be that should be implementing and not let us strive and action. Now we got to activate them. And while we activate them, we are potentially right now opening ourselves up for misconduct.
Of course.
We're going to be probably victimized, and I don't believe we will.
I was wondering how you are allowed within the system to even talk.
Ordinarily, we are not.
That's why
Ordinarily,
I
we're
was
not.
wondering when the inquiry for this interview came through, I said,
let me just
wait a minute.
read to you
Absolutely.
Something that shows how relative we are. We're not absolute. We're always going to be at another level.
You're sufficiently independent.
It's okay
The
for you.
CC in Van Rooyen held that there were significant guarantees, including the right to judicial review, that ensured that lower courts' judicial independence was not violated. It is not clear to me what the CC means by significant guarantees. So it's the same thing as saying sufficiently.
Yes.
Why significant guarantees? Why shouldn't our independence be guaranteed?
Guaranteed and absolute.
So do you see, just in that word that you use, the relativity that's being involved?
When you speak about sufficient, what are we saying? Remember, we've been saying it out there in the public domain that the lower court judges or regional court judges, we are regarded as the stepchildren of the judiciary. And that statement is a perpetuation of that narrative.
Let me
why?
just explain that section about significant guarantees. Considering this, let me read the section again. The CC in Van Rooyen held that there were significant guarantees, including the right to judicial review, that ensured that lower courts' judicial independence was not violated. It is not clear what the CC means by significant guarantees, considering that Section 12 of the Magistrates Act ultimately entitles the legislature to reduce the salaries of magistrates. The term guarantee is meaningless.
Wow.
So you can see
It's
that
pretty
it's a
obvious.
problem.
Yes.
It's a big problem. It's a constitutional crisis we are at. That is why we are with you.
Let us go back to the classroom.
Yes.
First year, and you're asking these learners, what is the implication of this mess? What is the implication of the judiciary being sufficiently independent and not absolutely independent?
The implication.
Yes.
The implication of our current situation, as you already know, we are in a constitutional crisis. You have magistrates that are undermined. You have magistrates that are going under debt review.
Yes.
Remember, I've already told you the jurisdiction that we have
It's
as
wide.
of lower court judges or regional court judges. At the end of the day, we preside over matters that deal with financial aspects, maintenance. We sit in the debt review court and it's a form of insolvency. Because when you go under debt review, it means you can't pay your debt.
That's it.
Largely credit agreements.
And
I'm presiding in that case.
And you're facing the same situation.
And I'm also going to be going under debt review. So what does that say about me acting freely, fairly, impartially? So maybe I'm going to have some type of prejudice.
Absolutely.
I'm probably more inclined to grant these applications to help the people.
You're prone to being bribed because You are
I
compromised.
hate to say that, but
Absolutely.
but
You're
that
human.
potentially
You're human.
But it can happen anywhere across the board, from the highest court
Yeah.
to the constitutional court, right to the bottom. But they are protected up there
Yeah.
from this. So,
And when you say protected, explain that.
protected because they're financially protected in terms of safety, all the goodies, the basics from medical aid, security, all those things. They've got it. We don't have it here. So we're not protected. And to my mind, if we don't have that financial
They are
independence,
protected in the
it's a problem.
Constitution.
Yeah.
The Constitution guarantees them the security of tenure. It doesn't guarantee us that. It guarantees them a salary for life. The Constitution does it. But we have no law that actually protects those very crucial aspects of judicial independence.
Yeah.
So
So
the-
in other words, we have no judicial independence.
So the lay people out there,
Yeah.
besides I'm talking about financial discrimination and going under debt review, what else happens to us? As I said, the aspect of security, that's a massive, massive issue. I mean, we don't have that type of protection. We don't have medical aid.
Yeah.
We don't have medical aid. Our lower court judges, and there's nothing wrong with our government hospitals, but we don't have the luxury to go to private hospitals. Our medical aid, you should know what the cost of medical aid in the country is.
Yeah.
So if a lower court judge is taking home about, say, I'm going to even play with numbers. I'm not going to mention these big numbers because that's not what we earn.
Yeah.
If a lower court judge is earning about 55,000, from that he must pay his bond.
Yeah.
Right, and you know what it is, what it costs. So
Take kids to school.
say 15,000 rand.
Yes.
Right, and then you're looking at your vehicle. I believe that a judge ought to have a vehicle, and he has to pay for it. We don't get any free vehicle. No. There's no free medical aid. And we pointed out about education. You know what varsity costs? And most of our kids have to go into private institutions. So that needs to be covered. Okay, insurances need to be covered. Food needs to be covered. Hey, maintenance of your vehicle, transport to and fro work.
Yeah.
So you don't have enough to make ends meet, so you must go under debt review.
You have to
Average
improve the
take home.
security at home.
Yeah.
And have you have to
Because we
pay
have
for it?
to. Yeah.
Who's going to pay for it? We don't get that. We don't get that, but we'll deal with syndicate crimes. We'll deal with murder, rape, robbery, cash in transit heists, bail applications in the district court and in the regional court. You actually hear it. And you're dealing with 5 to 10 people sitting in the dock. And you must be there, and you are the boss.
Yeah.
What boss? Boss of what? Boss of the court, and in giving you what you deserve in terms of sentence. But when you step out there,
Yeah.
you are left to your own
Let
devices.
me tell you that the way our salaries are being dealt with has been taken to the Constitutional Court
And?
already.
And how did that come out?
Let me just read to you what happened. Yeah, right. So the CC, in this instance of financial independence, as in other essential conditions of judicial independence, places a high degree of reliance on judicial review and the protection of the superior courts to safeguard the financial independence of judicial officers of lower courts through the review process.
Yeah.
There was this case called ARMSA versus the president about salaries. Let me tell you what happened there. The president refused to accept the recommendation of the IRC that we are supposed to get an adjustment. They recommended 7%. But the president said, no, I'm not going to give you the 7%. We're going to give you the 5% because that's what we can afford. That went to the Constitutional Court.
Okay.
And guess what? Constitutional Court completely and utterly decided that the president was correct.
Wasn't it on what basis? I want to play devil's advocate for a second.
Yeah.
On what basis?
What the case was taken on the basis that the president's decision not to
Increase.
to accept the recommendation was irrational.
Okay.
That one word is what caused the ARMSA to lose its case. They had these counsels who argued for the state that there's nothing irrational about what the president did.
Wasn't it an affordable issue, or they just decided it's an irrational?
Whether the question was never going to be about affordability
of the state, yes.
It was about whether that IRC recommendation was an adequate one, was a satisfactory one, which the president could have just signed off.
Yeah.
That
But
aspect.
they refused to do that. And what I'm going to read to you, the findings in Aramsa demonstrate how easily political organs can see off court challenges in respect of judicial remuneration when the laws protecting judicial independence are not constitutionally guaranteed in a trend.
100%. It leads me to my next question, but I'll ask after you make your comment.
Thank you so much. It's very important for us to appreciate that this argument, when it comes to us in particular within the judiciary, has always been used. We agree. There's a problem. We recommend this, but there's no money.
Yes.
Now, I want to deal with this aspect of money.
Yeah.
And you can see whenever there's an issue, there is a commission created and millions come up.
There's money for that.
And then there's always acknowledgements that there's millions and hundreds of millions being stolen, whether from municipalities, whether from departments. And we don't control any of this, by the way, the budget. So we cannot be stealing this money. But it's happening all over the shore. This country, our country, is one of the richest countries in the world in terms of minerals. And the minerals belong to the people. There cannot be that we have the richest country in terms of agriculture, tourism. We got everything.
Yeah.
We are servicing as a small number from the lower court at least 65 million in the country, let alone the number of people that are in the country illegally. So when you do the maths, one magistrate must service so many people. And what are we saying? And as pointed out, if you're an advocate or an attorney, you can earn what a magistrate earns in a month. You can earn that in a day.
Yeah.
So why would you want to become an acting magistrate or join the judiciary?
It's not an attractive
It's not
job.
attractive at all.
Yeah.
And I want to just digress a bit. There's this aspect of transfers. You know, magistrates, when you're appointed as a magistrate, when you want to transfer from one province, for whatever personal reason, your parents are ill or you have your reasons, but you've been in a certain province for a long time. We have to apply for a position at through the Magistrates Commission when there are adverts. When we have a person in Cape Town and we have a person in Johannesburg, same demographic group, that can just swap and transfer. Because you're a magistrate, you've been appointed, went for the interview, you're fit and proper.
It's
a no-brainer.
Yes.
But the Magistrates Commission has been not allowing that. In fact, they've been standing in the way.
So they want to apply.
It's abusive.
Yes.
So you must go and apply, and there is this likelihood that you won't even get that position. So what does it say? You're a magistrate, fit and proper.
You've been serving for 20 years.
And then they still think they have the discretion. I will call that audacity.
Yes.
They still think that they have the discretion to refuse. How can that be? Where's the fairness? Where's the rights?
Yeah, something is
Where's the human rights for us? We don't have it.
And yet
we are protecting the Constitution.
You are the people that are supposed to uphold.
We are protecting the Constitution. But who protects us? When I hold the book, I just didn't carry it today. It's in the car. When I hold the Constitution
it's there. We have it there. I want you to hold it.
Yes, please.
It's on the table somewhere.
No, I like to hold it. I want to hold it, but it's fine.
Yes.
But when I hold the Constitution in my hand, I tell everyone, as judicial officers, we are protecting and upholding this Constitution. We are enforcing it. But this Constitution, unfortunately, is not protecting us.
Let me ask, and bear with my insistence of always going to a classroom, because it simplifies the matters.
Yes.
You spoke about when you were reading that the independence becomes questionable when an executive has the upper hand and the final decision of whether there's an increase or not of the salaries.
Yeah.
It's a very simple concept to grasp, that I'm not quite independent from you if I rely on you to give me money. Or when I need more money, I still have to come back to you. It's a very simple concept to analyze. But because of how our country is designed, the money comes from Treasury.
Correct.
Comes from our taxes, goes to Treasury. Treasury disperses it through the Ministry of Finance. Now I ask now, it's a philosophy class now. And you're asking your students, can the judiciary, all of it, including the lower courts, including Chapter 9 institutions, because they carry the same type of discretion. It's an appointment by a president, so forth. They have to be independent from the system, so they can make their decisions independently. Can those institutions truly be independent?
They're not.
Since money comes from the same purse.
I can tell you it's not. You know why? Not because of the money coming from the same purse.
Okay.
It's because of the level of accountability. They are accountable to various institutions themselves. The public protector is not our own institution. She is accountable to Parliament.
Yes.
The NPA head is accountable to Parliament.
Yes.
The judiciary is not. We're not accountable
to Parliament.
Anything but the Constitution and the law.
100%.
There's a huge difference, and I also dealt with that in my thesis.
So they are not the same as you.
No,
Chapter 9 institutions are not the same.
They can be called independent, but when it comes to, they are worlds apart from the judiciary. Imagine the public protector saying they have more status and better status than the lower court judiciary,
which is the case now.
Which is what they are exactly doing.
To follow up on that very question, when there's mismanagement of funds by the higher court, remember they have independence of how they control their monies, am I understanding?
Yes.
Should there be mismanagement of funds?
Yes.
Who do they answer to?
Remember, when it comes to the higher court, you have the office of the Chief Justice. The judiciary ordinarily is not directly, but obviously the exercise oversight would be through our Chief Justice.
Exactly.
And if there's any irregularities, the irregularities ordinarily would happen through the administrative component, and they are accountable because it's not unusual. No, because they can be charged. Obviously, the normal laws apply.
Yes.
Because it's not unusual to have heard that the office of the Chief Justice was compromised with some type of tender. We've heard that. It's been in the media.
That's why I'm asking.
So people get arrested. They must go through the court system. They come to us. They come to us.
They come to your court.
The higher court administrative component, when they get arrested and for bail applications and they need to go through the criminal trial, largely they'll come to the lower court or district court judges.
The OCJ was created by regulation by the minister.
Yeah.
It's not a parliamentary law that created them. So they are very, very much an element of the executive. Yeah. That is why the higher courts are complaining because the OCJ is not theirs.
Remember, the Department of Justice, as you mentioned, the different Chapter 9 institutes, the Department of Justice is responsible for us in terms of the administrative support. Staff support, tools of trade, they come in. Yes. When it comes to infrastructure, we are looking at the Department of Public Works. So now there's bureaucracy. We got to run from here, pillar to post to deal with. And then don't forget, let's not leave out our salaries and benefits. That's where the IRC comes in. The IRC comes in to do their job. And had they been doing their job correctly, we wouldn't be sitting here. And remember, there's regulations that need to be passed that control us through the minister when it comes to leave, transfers, we've mentioned.
All of that.
And remember, the minister is technically our de facto representative in the government employees pension fund. One of the things we are making sure that you understand, we need to get out of the government employees pension fund. We are not public servants. We are public office bearers. That concept is very simple to understand.
That's true.
The Constitutional Court, Parliament, everybody understands that. But why don't you implement it? We need our salary for life. Pay us out our pension. We can go and invest it in Alexander Forbes or whichever reputable company. I don't know. But that's what we need to do.
You know what I call this transition from the public, from the purse of the executive to the POBs. That's the biggest scam that have been pulled up on the judiciary.
Explain.
It was a scam because we got moved out from the public service where we used to get the benefits that public servants used to get. We are now moved into the public office bearers, which sounds like a status improvement, to the public, it is a status improvement because now I'm put together with all these very important people in Parliament and with the important people in the higher judiciary. But do you know what? They didn't move our salary arrangements at all.
They just gave you a tag to get into VIP, but your life didn't change.
And it got worse because public servants started to get improvements in their salary.
Oh, that side got better.
David, you can see how passionate Dr. Rawheath
No, she is. And it's actually quite fascinating how passionate she is for someone who's retiring so soon.
But she has not lost her energy and passion for the cause.
Yeah.
And she, by the way, Dr. Rawheath is also an admitted advocate. She's going to be representing us going forward.
Done.
And she's going to be, she's going to be in the thick of things. So she's not leaving us.
Yeah, okay.
She's going to be with us.
I was worried you'll be lost to the fight.
We will not lose her.
Yeah.
And we're grateful for that.
Thank you.
But also on the aspect of public office bearers, it was a noble and it was the right thing to do. Let's put it that way.
Yes.
We are public office bearers, rightfully so, in the right space that we're supposed to be at.
Yeah.
All that was supposed to happen was action and implementation. We boiled down to the same thing. Deliberate neglect to keep the status quo and appease. And someone is saving money. Someone's making money. And it's a power issue. Why do you want to control the lower court, which is the largest component?
Yeah.
And you are controlling us because we are scared. A lot of us are scared. They don't want to do this, don't want to. But we are not scared.
Get you in trouble.
But remember, we are radical, we are fearless, we are unapologetic because we're doing the right thing. Can you imagine this whole discussion? Have we said something that is hurtful to you, that's unconstitutional?
That is scandalous.
What we are doing is we are literally changing an arm of government, and we accept and appreciate it. In as much as we might be victimized, our work is going to be picked on, and whatever we do in our private or public life, so be it.
Yeah.
This journey is never going to be easy.
Not at all.
But we are getting there.
Let me ask, as we head towards our conclusion, ministers and political office bearers, they have an expiry date. The Constitution says that.
Absolutely.
They come in and go.
Yes.
Whether it's 10 years or whatever, 5 years. And again, they are prone to be removed by the president overnight.
Yes.
That's right.
We've had many. In the 17 years of no salary increase, for example, we've had probably 5 or 6 different ministers.
Yes.
And they come in, they walk into a department from Department of Water.
Yes.
They're walking into Department of Justice or Department of Tourism or something.
Just get reshuffled.
And they reshuffled. They walk in, they have to understand the system.
Yes.
They have to understand what you guys do first and foremost.
Yep.
And in a conversation that I've had earlier, we discussed how the court on its own is such a living organism that if you don't understand how it works, you're not likely to be able to fund it properly. Or look after judges properly and everything that comes with it. Am I correct?
You're absolutely correct. By the time you find your feet in those 5 years, you just figured it out, you have to leave.
Yes.
But remember, our Minister of Justice, Honorable Kubai, she has been in various different portfolios. She's in Parliament. Within government.
Yes.
Yeah. She's a very strong leader. She's very aware of what our situation is. Now, all we need to do is make sure we convince her to action everything. Because she's got the ability, she's got the know-how, and she's got the skill.
Yeah.
And she's got a strong team with her. All that needs to happen is there needs to be that political will. When we say single judiciary, do not tell us that we're going to amalgamate the Judicial Service Commission and the Magistrates Commission when we have time. It's too difficult, or it'll take too long. That's not the point. Get it done.
Yeah.
We worked on our and we've got people within the judiciary can help with legislation.
Yes,
True.
So we will give you
There's
the people to do your job.
Yes.
So get it done. Everything that needs to happen. There's talk about 2 phases. We want to do this administrative transfer phase, and then we'll do the legislative phase. Now, to my mind and to our mind, that is, I don't like to say nonsense, but that's not acceptable.
Yeah.
Let's say nonsense. It's actually nonsense because
Yes.
it can be done in one go. You change legislation, everything flows from legislative changes.
That's it.
You have to put the horse before the cart.
The cost effective. It's the most cost effective thing to do. Imagine starting a whole different law at a different time.
No, and it's going to take forever. Do I want to end up like in Betty's position? She's already retiring.
Yeah.
And she's
And
been
it's
in the
not-
same system.
And we're going to fight now for whatever benefits we receive must be retrospectively applicable.
That was another question I wanted
You
to
understand?
ask.
Because she needs the
there's
benefit of it.
So many retired before her.
Because she needs salary for life. She's given more than 40 years of her life
I'm not
to the
going to get
system,
it. I'm not holding my breath.
which is fine.
I hope you get it.
But one question I really need to come back. I
Yes.
don't agree with you
Okay.
that I'm pleased about being a public office bearer.
Okay.
Because I don't want to be lumped in with politicians. Why are we put together with public office bearers? Why? And
You-
in fact,
you
it actually brings us into
The
as if-
independence issue.
Yeah.
You give the impression
but
that there's something good about
At
it.
the end of the day,
Yes.
we just need to be ring-fenced as a public office
Yes.
bearer. Public office bearer is what we are, just because we are an arm of state. Executive, legislature, judiciary, all of them are public office bearers, isn't it?
Absolutely. Yes.
So, but
they answer to all of
we
us.
have different functions
Within.
So you need to ring fence us and treat us as judicial officers.
Yeah.
Don't lump apples and grapes. You know,
But
things
we
need to
don't
be.
even
Unless
need
you're
the-
making a fruit
we
salad.
don't need the label.
Exactly.
We don't need the label.
we don't need
are
a label.
judiciary.
Yeah.
Come on. Why do we need a label?
Which is fine, but that's neither here nor there.
Yeah, but anyway, I've been fighting for that a long time, asking that we be moved out of this public office bearers and be separated so that our remuneration can be decided completely differently, together with judges who get salary for life.
I want to conclude this by asking both your perspective and the same question. What should the public understand about the state of affairs with regards to lower court judges? You've answered this in many ways, but I want you to sum it up and say it will affect you if you find yourself in the court system as an ordinary David. What should I understand about this quagmire?
Absolutely, David. Remember, we have the option of going into court, and we will be going to the Constitutional Court direct access. But we are not moneyed. Our members in JOASA pay an amount of 200 Rand per month. So we have limited funding as compared to when we tackle the state. They've got unlimited purse and they use our own resources, our own tax money to fight us.
Fight you.
To fight an issue that they ought to know is unconstitutional on their part. So we have to just continue. And we rely on the goodwill of our friends, of other associations, and the public at large. Remember, we've got support from our traditional leadership in the country nationally, and they are supportive of us. So right now, what's expected of us is we will continue this fight. We will continue with this aspect of public peaceful awareness. We're going to escalate now to the work to rule. Now, the shutdown is a different issue. That's something that we are going to...
drastic.
It's very drastic.
Yeah.
But why should we even get there? We don't want to get there. So, but right now, the public at large must understand.
That
We
no-
don't
have
want
no
to be here.
recourse. We have no recourse.
We don't want to be here. I mean, when we are taking this stance, they need to appreciate we are currently in a state of a constitutional crisis. This judiciary is in trouble.
Yeah.
Let us save it from the top to the bottom.
Sure.
So we expect.
Let me phrase it differently for you. There's a word that keeps coming up, and I think it's captured also in your thesis of the lower courts are ignored. That's a phrase that I've seen in reading in preparation for this. It's almost like as you called it, the stepchild, who's not, like, whether they've eaten or not, it's neither here nor there. What is the true cost for our democracy, for our people, for this situation to carry on, this system to ignore the lower courts, if that's the word we should be using in this context?
Maybe the word ignore doesn't cover the darkness in it. The darkness is the fact that every court user who uses the lower courts is actually a second-class citizen.
Because of that.
Because of that. Because they have to come to us. And if we don't do the very best we can for them.
Because you don't have the resources.
Exactly. That means they are all second-class citizens. If you go directly to the Constitutional Court, you have the privilege of being heard by the most competent and well-known counsels. They all moneyed people. They all have corporate funding. A lot of our cases go from corporate disputes. All of that is irrelevant to those people who come to us every day crying, please assist. And as I said, every one of them has a story. And I have to listen to that. And imagine the moment they step in, they're already second class, because I'm not going to be able to do for them what a court is supposed to do in terms of Section 34 of our Bill of Rights, which says every dispute can be resolved, must be resolved by a court of law, an independent court of law.
Oh. Yes.
Why should our people settle for getting sufficient access to justice? That's what it implies.
That's it.
Yeah.
So our people on the ground, and our masses, our 65 million of citizens that we are servicing, must receive sufficient cover and access. Just enough to be sufficient.
Yes.
Not full, total, adequate. You understand? That we need 100% cover. Why should we settle for less? South Africa, as I say, has the best constitution, one of the best in the world. So we will not settle for anything less but 100%. We expect the powers that be. And we've put them in power. We all generally vote. So the people that
don't vote, we vote.
Whatever we do something.
Yes.
We do something. So it's our money that's involved. This is our country. So we want the best. We don't settle for second rate, no. And we're not striving anymore. We need to maybe change something there.
Yeah.
We're not striving for freedom. We're free. Give us what we're entitled to. Don't tell us there's no money. Because when you're looking for money, you find the money. All the time. So do we need maybe a commission of inquiry into the state of the judiciary?
The independence.
Is there any capture of the judiciary?
Absolutely.
And if that's the case, millions will be found tomorrow to get it done. But forget about that. Sort the lower court judges out.
Forgotten that we're actually the
Let's get it
third
done.
arm of government.
The third arm.
We're an arm of government.
Absolutely.
Can you believe it? If the majority of the judiciary is in the lower court, that means the judiciary is in the lower court.
That's it.
That means
That's
that
it.
whole arm of
90
government.
what percent?
95%.
That means the whole arm of government has been captured.
Wow. That's scary.
It's dangerous for our democracy. That's a message I want to get across to anyone who would listen.
Here's a question that's partly linked, but maybe not. And we'll conclude on that. We call our constitution the best in the world. We say that a lot. You represent this very constitution in your courts every day.
Absolutely.
You make reference to it when you're giving someone bail and so forth and so forth and so forth. And everything that you probably decide. What makes it best?
From our historical perspective, you already know about the human rights violations, apartheid, and the fact that we have a Bill of Rights within the Constitution. And those are such important basic concepts and rights that we have as citizens of the country.
Yes.
And every person, whether you're a citizen of the country or not, when you are in this country, you receive the protection. And that's what makes our constitution so great. And expanding on the different aspects from equality, dignity, freedom of speech, those things we didn't have. But we have it there now. And legislation, Parliament has been quick. To promote and progress on all these different... They look at equality, then they created PEPUDA, Equality Act, and then magistrates now need to become equality court magistrates or judges, and that's what we do. We deal directly with constitutional issues. When it comes to evictions, right to homes and whatever, PI Act, ESTA, we are dealing with that. So we are now dealing with that legislation now, magistrates. But when you look at the courts, and the term courts, the magistrates are ignored. Everyone else is reflected. So that to our mind obviously is a problem. We're going to need legislative changes.
To answer the question, you go back to why the Constitution is great. Remember that much of the Constitution that was discussed came from the principles that were set down in the Freedom Charter. And the other...
after everyone.
Yeah, and then a big part of it is the Freedom Charter. The other part of it was from the United Nations principles of how a constitution should reflect every basic right of every citizen to be protected. So in the past, it's not like other countries didn't have these rights. They had it under a different system, which was based on parliamentary sovereignty.
Gotcha.
So for England, for example, they don't have a constitution, a written one, but what guides them? Conventions. So what we got into the constitution are actually kind of parallels that they use in their conventions, which guide them as to how they must protect their citizens.
Yeah.
So it's very important that the reason why ours is regarded as a great constitution is because we've put down in code what these rights were that were all over the place. Yeah. And one of the important things that we included there was sexual orientation, which no other code has actually got there, which is an important right. Because people were being abused simply because they have a different orientation. And obviously we saw that that was cruel. So we were able to go a little bit beyond that because of our struggle history. There were different struggles. Imagine this community that was LGBTQ. They had no voice before.
Ostracized.
But they were given a hearing during this CODESA hearings. They were given a hearing. So it all got included in there. And now all the basic freedoms got included. Remember, the other constitutional democracy is the United States. But our constitution has gone well beyond the United States Constitution. That is an old one, but they still keep it. But we have developed it. And ours is really the only one that's codified to that extent every human right. That's why it's the best constitution.
I want to conclude and apply to your courts, and maybe it's not the right court, but I will anyway, and say there's a class action case that's pending, and that speaks to the very constitution you just spoke about as South Africans, when we put our heads together and say the right to dignity is not well enshrined. We don't, it's captured, it's in the constitution. However, we don't see it in reality. When kids have to fall into a pit toilet, when hospitalization becomes a crisis, when you go there and sleep on the floor for hours because you're waiting for a bed, when you cannot get the right level of education in some parts of this country. It's a class action case that needs to ventilate the right to dignity, because I feel words like dignity are easily thrown in there. And yet it's the second line of the Constitution, the word dignity. Yet to bring it to life becomes a complicated thing. What does it mean exactly to give someone this dignity, for them to live?
It's an abstract concept.
Absolutely.
Yes,
and is open to a million interpretations. And the question is, when somebody lives in a shack, in a modern South Africa that is as rich as you've described it earlier, do we consider that the right to dignity? We said they have a right to be looked after and accommodated, but is it in a shack? That's the question. Where's the dignity there?
Remember, in terms of our constitution, there's always that term that's been there, but it's been there for a long time, about progressive realization of these types of aspects and rights.
So we are on the journey.
So we are, but progressively. But the difficulty is we can utilize this class action, as you say, because it can happen depending on where the jurisdiction lies, it can happen in the magistrates court, the regional court, or even in the high court, because you are dealing specifically with the aspect of dignity. And if you are talking about health issues and hospitals, because the manner in which the Department of Health may probably be running a specific hospital, and they got a certain budget, and there is mismanagement, they can be held accountable. Absolutely. Because people should not be being on after 31 years of democracy, for us to say that our people must be on the floors, don't have proper health care. And I'm speaking about medical aid and private medical aid, mind you, because we are supposed to be going into the National Health Institute, NHI. And how far are we from there? And that's another hot potato.
Yes.
So
Maybe
people can be held accountable because we can make orders asking for an apology. We can give directions. Certain things need to be actioned at a certain time. And in terms of the Equality Act, you have vast jurisdiction. So it can be utilized. Just as we...
You can get a class action.
You can get
just as we, in terms of systematic economic discrimination, we as lower court judges have a class action exactly on each of those aspects when it comes to dignity, as you say.
Anyway, that's my story and that's your story.
Thank you so much. I really appreciate you having us.
I appreciate you making your time, giving your time to this conversation. And we have to agree, most of us didn't understand some of these aspects. We think the court system is one. Because it's only those that are educated enough in law to understand that. We think you're all brothers and sisters living happily in one home.
We are trying. We're trying.
Yes.
But did you understand? Did we break it down effectively?
100%. I got it. I hope
grateful.
everybody else understands.
I mean, if you got it, I'm sure everybody would get
That's the idea, isn't it?
Yes, because you can bring them down into bite-sized portions, make sure that every concept is unpacked a little
100%.
bit.
You know, for like I said earlier, you know, when I read, there's a line that I read that I think you said for the last 17 years, magistrates have been ignored and sidelined. And there's a point that you said, because I have your quote here, it says, we have been facing this challenge for the past 20 years, where relevant are explicit, and you draw really these realities that even in your thesis that for us to be here, it's just a shame. And 42 years in the system, and very little has changed in your lifetime.
Yeah, nothing has changed pretty much. Yeah, but, I'd like to think of us as hopeful, leaving this studio today.
Absolutely.
I like to think of us as having hope because, sometimes even good people get caught up in all the noise around them and they feel silenced.
Yeah.
And once you silence someone good, you've destroyed some essential part of the fabric of what our progressive movement is.
Imagine if Nelson Mandela was silenced.
Yeah.
And we reflect on things like that.
You can't be silenced. That's why speaking with you here, I feel grateful that the one thing I think we still have, as long as I'm not a whistleblower, I think I can express myself.
That's true. That's the one thing we do well in this country. We have the freedom to express. What saddens me about that freedom to express, we have our leaders who say, you're right, man, we hear you. That's a good point. And then it ends there.
King David.
Yes.
I'll call you King David. I think it's appropriate. We are grateful that you are walking with the JOASA and the lower court judges in this journey.
Yeah.
It's a long journey. Although some people think we are at the end, I think we are far from it because of legislation.
Yeah.
Thank you for the platform.
Thank you.
We are very grateful.
I appreciate it.
Much appreciated.
Thank you so much.
Thank you.
Wow. If you got this far, you might as well subscribe. Thank you so much.
King David Studio Podcast.